Good afternoon. May it please this honorable court, Kareem Johnson, on behalf of Martina Smith, who's approaching to my immediate right.
Your name?
Martina Smith.
All right. And what are we doing?
Your Honor, the defense is requesting an adjournment in this matter. There's been a breakdown in the relationship between me and Ms. Smith. She is seeking to retain private counsel.
Oh. Didn't she, other than the public defender, didn't she have an attorney before you? Or no?
No.
Okay. Maybe I'm thinking of a different case. All right. Ma'am, what seems to be the problem?
I just don't. I don't feel comfortable.
I don't know what that means.
Well,
Your Honor, she believes that I am working with the prosecution. I've tried to explain to her.
Excuse me? Oh, no, go ahead. I want to hear this.
I've explained to her that under Michigan's R&O statute, there are 7 different ways that you can obstruct an officer, including just talking back or ignoring the officer. We've had an agreement for HIDA. I thought we had that agreement worked out. She had me speak to an individual who I believe was her father, who indicated that he was a paralegal, and gave me his MDOC number and instructed me to actually hold the exam and let you bind it over. I refuse to do that because I believe the prosecution will be seeking to add an additional at least 4 counts of R&O for the other officers that were there. And I told him that what I would do is I would ask for an adjournment because having additional charges added plus walking away from an agreement where she would have no record, she'd be in 25, so she needs the prosecutor's consent for HITA. I felt it was best for her to just get somebody that they feel more comfortable.
Well, okay, so first of all,
you never said nothing about
I've known
the
Mr.
charges.
Johnson a while. And what?
You never said anything about adding charges on her or nothing at all. That's not true.
See, here's what
I didn't.
I'm a bit concerned about, because now you're gonna try to overtalk me. Go ahead. I'll wait. You done? Are you done? First of all, I think, because I've watched this attorney in my courtroom on various occasions doing things. And I don't know how he stands there and not take offense when you're saying he's working with the prosecution and forsaking his client. Because this man would never do that. Ever. I mean, I that's what I just find kind of just crazy. And if he really thought it was in your best interest to have the exam, there is not a doubt in my mind he'd hold the exam. So that's the first thing. And I was right. This is now the second attorney. Because as my staff would remind me, I was looking for the paperwork. You had Mr. Elman before. And you basically had that same complaint. You don't get to continue to choose attorneys. So I guess part of the problem is going to be, this is set for a preliminary examination. And I understand that part of the reason that counsel is asking for the adjournment is really to save you. I am almost of the mind that you don't want to take his advice. You don't want to do whatever. Let's hold the exam. If you get charges at it, you get charges at it. That's your call. But I'm not removing him from the case. So now what do you want to do? Because we're not going to play this game. Ma'am.
Your Honor, may I?
Yes, sir.
Because of the conversation that I've had with her father, I'd humbly ask the court, if the court's not going to remove me, to just grant a brief adjournment. I've never asked this court to remove me from a case ever.
I know.
But we have somebody who has not looked at the body camera footage, advising his daughter on what to do in a criminal case in which she could walk away with multiple felonies. So I understand the court's frustration. I understand the court wants to move in the docket, but this is not her request. I am asking for, at the very least, an adjournment in this matter. So ultimately, she can have counsel that they feel confident in and make a decision that is not going to negatively affect her.
Well, people have a position regarding adjournment.
We certainly no position regarding her counsel. People do not object to an adjournment, Your Honor. People release the witnesses because we were under the impression that an agreement had been reached, and then that fell apart. So people certainly could get the officers back if the court orders to do that, but under the circumstances, we would not object to an adjournment.
I'll grant the adjournment. I can give you, because it's got to go before me, I can give you next week or the 13th, I think is.
What day next week, Your Honor?
The 30th. It'd be Tuesday next week.
That's fine, Your Honor.
That'll work.
Yes, sir.
Preliminary examination in this matter will be adjourned December 30th, 2026. 9 a.m. That's at 12 noon. That's before me.
Yes, sir, Your Honor.
Ma'am, I'm just going to give you a fair warning, and I mean it. I'm not playing this game with you and the attorneys. Either you're going to listen to them or you're going to have an exam, and then the chips are going to fall where they may. If there are other charges and other things added, that's just going to be too bad for you. But if you think that man sitting next to you isn't trying to save you and put you in the best possible position, well, that's your fault. Because apparently with your law degree, and whoever else with their law degree knows more than he does. Bond will continue.
Thank you, Your Honor.
People.
Good afternoon, Your Honor. Alex Warren Green on behalf of Ms. Rogers. Ms. Rogers, could you please state your name for the court?
Jesse Rogers.
Thank you.
Your Honor, thank you. Good afternoon. Today, the date and time set for the preliminary exam in this matter. I had an opportunity over the weekend to review the reports. I spoke to Mr. Warren Green. There is a handful of documentations that are alluded to within the report that neither party simply has. I went through it and I'm not sure, it doesn't look like it ever happened. I reached out to the records department of the sheriff's office as well as the OIC, who now is at a different police department. And they're looking into it, but I've not received those documents as of this time. I am unable to adequately perform this exam. And so I'm going to respectfully ask for.
Why weren't, I don't understand.
And Your Honor, our position is I'm asking for a dismissal. When we set this examination, I set it with the understanding that we had everything the people had. And I believe that to be true today. I'm asking for a dismissal because I don't think it's the case that discovery is incomplete. I think the people are simply missing evidence they need to move forward with this case.
Well, which is it? I mean, there are things referred to, what I got out of that was there are things referred to in the report. Do we know whether they exist or don't exist? And if they exist, why haven't they been given to the defense prior to now, and certainly prior to the time that this examination was set?
So the report refers to a couple of different items, i.e. a spreadsheet from the University of Michigan Credit Union, as well as a phone call. And it says that the phone call was uploaded to evidence.com. I go to evidence.com, I don't have it. It's just not there. The spreadsheet, there's something that might be the spreadsheet, but I'm not sure if it is the spreadsheet. So there's things that are in the report that I don't feel comfortable. The phone call, I just don't have. The spreadsheet, maybe it's there. I'm not 100% sure that that's a spreadsheet. It doesn't look like a spreadsheet, but.
I don't know what that means. Is it a spreadsheet or isn't it? I mean, if it refers to a particular document, I think you'd be able to try to figure out what it is.
I think if it was copied and pasted from Excel and then into a Word document, it would have just been a formatting error that I wouldn't necessarily be able to make heads or tails of.
And Your Honor, what the defense is in possession of is what purports to be the complainant's banking app records. Those are contained in what is a spreadsheet, and that was produced. What I think the people are missing is Verizon records that are mentioned in the report, but were not produced, are not in the people or the prosecutor's office possession, and certainly haven't been turned over to the defense. I believe we have everything they have.
Why are those records as a proffer necessary for the exam?
The way that I believe that I can prove the case is to show the connection between the defendant and her use of an IP address that comes back to her phone number. And I don't have any of those documentation.
Then how did it get charged?
It's a good question, Your Honor.
Oh, yes, it's a good question. And I don't know whether she's guilty, not guilty. She's presumed to be at this point in time, but she's been going through this process and get to the date of a preliminary examination, her first step. And you're telling me you can't show the case and that there's something out there that you don't have, never had, that would link her to this case. So why is she? Going to grant the defendant's motion. This case is dismissed. It is without prejudice. So, ma'am, you need to understand that they can bring the case back, but I'm going to give you fair warning. You bring it back, you better be ready to go. You better have everything that would tie this defendant to this case, or there are really going to be problems. Thank you.
Thanks, Your Honor.
Thank you, Your Honor.
People.
Good afternoon, Your Honor. Jay Grant Miller, P58658 on behalf of Jonathan Hughes.
Jonathan, who? All right. I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Plea form indicates that the defendant will be pleading. Well, it's not checked. Is he pleading guilty?
He's pleading guilty, Your Honor.
He's pleading guilty to the charge of use of a controlled substance, that being cocaine, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of it.
Yes, Your Honor.
Mr. Emmons, that is my understanding. I think Mr. Emmons will verify the plea now.
Yeah, thank you, Jonathan Emmons, on behalf of the people. We have this case. Going to have a plea to an add account 2.
I think I already said this if you've been in the room.
Do I confirm that?
I have it.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Jonathan Hughes. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of use of a controlled substance. Yes, sir. Cocaine. Yes, sir. That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that? Yes, sir. You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court. Yes, sir. All right. Still wish to plead guilty? Yes, sir. And to that charge, how do you plead? Guilty. Now you understand by pleading guilty, you'll not have a trial of any kind? Yes, sir. You signed an advice of rights form, is that correct? Yes, sir. Any question regarding any of those rights? No, sir. Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of the trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
Notice the contrast here. Unlike earlier chaos, this plea is calm, methodical, and legally airtight. This is how the system works when everyone understands their role. Clear rights, clear consequences, and a clean resolution.
Rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
Yes, sir.
Were you on probation or parole at the time of this offense?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will
Yes, sir.
and because you believe that you're guilty of this offense?
Yes, sir.
January 19, 2025, at the location of Harriet Street, Ypsilanti City, Washtenaw County, State of Michigan. Did you have cocaine in your possession?
Yes, sir.
Had you used it?
Yes, sir.
Did you know what you were using was cocaine?
Yes, sir.
Sir, if I accept your plea and you commit misconduct between the time I accept your plea and the time of sentencing, you would not be entitled to withdraw your plea and the court would no longer be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule?
I'm satisfied with that.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
January 7th at 10 a.m. before Judge Barr.
January 7th, 2026, 10 a.m. before Judge Barr.
Yes, Your Honor. If I could address the bond condition, Your Honor.
Sure.
He actually has a release to treatment and he's being held on those cases. We were just requesting that this court would consider releasing him to treatment. I believe there's a bed available for him, and this was the last thing keeping him out of treatment.
Any response from the people? Prepare an order. As usual, I'll sign it.
Thank you, Your Honor.
Thank you, Your Honor.
At this point, your bond will continue. Once I get that order, I'll sign off.
All right, thank you, sir.
Thank you. Court does call the case, People versus Jesse Lee Rogers.